Today's video feature is what is the process to value a workers' compensation case? Now, every lawyer has a different way of doing this. I have my own style. It's a style that I've been using for over 31 years. But what I do is I get to a quiet place. It's usually in the evenings or even on the weekends where I won't be disturbed or distracted. And I have the client's full file, including all medical records. And I segregate out the medical records to have them by medical provider, and I go from beginning to end. I literally look at every single page, every single line, and I highlight with a yellow highlighter those portions of the records that I think are valuable in presenting the best case for my client. Now, once I've reviewed all the medical records in full at one sitting, then I have a very good idea of just what my client has been through and what they're facing in the future. Now, we start with the impairment ratings given by the treating physicians. In many cases, there may be more than one rating. For example, one doctor treated my client for his back, while another doctor treated the client for a knee injury. These are serious cases, obviously. Now, we can calculate the value of the impairment rating by taking the percentage of the body part times the client's compensation rate, and then we know exactly what those ratings are worth. That is the baseline value of the case. Then we also look at the client's age, education, work history, any permanent restrictions, and future medical care needs to try to get a value of what we expect a commissioner would do if we go to a hearing. Now, the older you are, the better. The less educated you are, the better. Obviously, if you have extreme permanent work restrictions, that also helps your case. Notice I mentioned nothing about pain and suffering because there is nothing for pain and suffering in workers' compensation law. Then once I have those figures and those estimates as to what I think the value of the case is, then I reach out to the adjuster or, in many cases, a defense lawyer. If it is a serious injury, then we absolutely need to go to mediation, formal mediation, so that we can negotiate a best number outcome for our client. If it's something more simple, such as a single member injury, person is returned to work and they have an impairment rating, oftentimes those cases can be resolved over the phone. So the more serious cases need to go to formal mediation because that's how you get the best number. And if you're not able to reach a resolution either by phone or at formal mediation, then your last option is to go to a hearing. But I will tell you from 3 decades of doing this, you can almost always get a better number at mediation than you can if you go all the way to a hearing. You also have more control at mediation, whereas at a hearing, your fate is in the hands of a single commissioner. They'll do their very best. They'll be as fair as they can, but I know most clients like to have a hand in the outcome of their case. I hope this video was helpful. If you have any additional questions, you can reach out to me directly. My name is Robert Reeves. My mobile phone number is 704-351-7979, or email me robert@rjrlaw.com. Thank you.